Debbie Moraes, and once again, this is Legal Matters, the program that's been designed to address the critical issues facing consumers and businesses. It's legal information, it's practical solutions, and straight talk about a wide variety of topics that affect your work and your home life. Last session, we were talking about contracts, writing them, enforcing them, who needs them, how do you evaluate them, how do you keep from being on the short end of the stick. How do you end up developing one? Can you do it online? We hope some of those things were helpful to you. Today we're going to discuss what happens if you happen to be on the short end of a different stick, namely you happen to lose in court. In judicial terms, I guess that means the appeals process. So we'll have our lawyers weigh in and tell us a little bit about that process. Once again, Jackie Grasso and David Bazar from Audette Bazar, Cadero Grasso Law Firm in East Providence. Whether it's your traffic violation or Amanda Knox, I guess appeals happen. So let's do a little bit of a tutorial. Who gets to appeal and on what grounds, and how does that happen?
This serves two functions. An appeal either is going to redress a legal issue that happened at trial, and or they'll further some type of legal principle that didn't happen at trial.
And it depends on what kind of case we're talking about. So we need to walk through different types of cases and talk about the process in each instance.
There are many levels of courts of appeal. Can you tell us about the distinctions between the two, the ones that are in Johnston versus...
Well, courts of appeal vary from state to state. So, for instance, if we're talking about a federal court issue, it would go from federal court over to the...
Well, Federal District Court, say Rhode Island, to the Circuit Court of Appeal.
The First Circuit Court of Appeal.
Right.
And if you lose there, the only other place you can go is the United States Supreme Court. Now, if you're talking about a traffic ticket, there's a Rhode Island Traffic Tribunal that does hear appeals. They have an appellate panel. I believe 3 of the traffic judges sit on it.
Right. So let's take the process from the beginning. Someone comes to Jackie's court.
Okay.
Okay. They have a ticket in Bristol Municipal Court. They have a trial. Jackie makes a finding of guilt, perhaps, and the motorist wants to appeal. If the motorist wins, the town could appeal as well.
Yes.
But let's just say in this instance the motorist is lost. So what happens now is the motorist has a certain time frame, and you got to be careful because different types of cases have different time frames. But there's a time frame that you have to give an issue or a notice of appeal to the municipal court. You have to get a copy of the transcript from your hearing, and then you have to bring that over to the Rhode Island Traffic Tribunal.
And the filing fee.
And pay the filing fee.
If you go to Jackie's municipal court, I assume you show up without a lawyer most of the time.
Usually.
But if you needed to appeal the case because you weren't satisfied, you lost or whatever, to go to the next step, must you have a lawyer then?
It's probably advisable if there's some type of legal issue that you want to bring forth, but I think most of them are representing themselves.
Yeah, it's not mandatory at that level. It's always advisable if you're going to argue a legal issue, and most appeals have to be on a legal issue unless the judge clearly abuses his or her discretion on a finding of fact. It's a legal issue that gets appealed.
Give us a quick tutorial on what might be considered a legal issue. I know we're going to be talking about Blagojevich and Amanda Knox and some of those others if we have time today, hopefully. But what is considered to be a legal issue on which you have a right to appeal?
All right.
I can give you one from bankruptcy court. As you know, when you file bankruptcy, you're allowed to exempt certain assets. So assuming we exempt an asset, the trustee objects to it, then that goes to hearing before the bankruptcy judge. If I get a disfavorable ruling, then my client can then appeal that issue on an exemption, and that would be going to the bankruptcy appellate panel. They would hear the same issue. Either they would remand it back to bankruptcy court to be heard again, or they would rule maybe in my favor, or if they rule against my client, then I can go further. I can go to the First Circuit, United States District Court in the First Circuit.
Right.
Which is where?
Boston.
Right. Now, another example might be, I had a case in East Greenwich Municipal Court, and it was a violation of a stop sign, obedience to a stop sign. And the woman's testimony was that she stopped behind the line some distance, couldn't see to the left because a building was blocking her view, and then took off. Unfortunately for her, she took off right in front of a police officer who was coming the other way up the street and cut him off. So he issued the ticket. probably some other things too, but the ticket was what was issued. So she had a trial. And if I had made a finding that I didn't believe her, and the police officer had testified that he observed her never stop, the wheels kept rolling, and that she never stopped at that stop sign, that would be a factual determination. The appellate court could listen to the testimony and find out whether there was any abuse of my discretion in making that finding or not. But that's not what I found. I found that she had stopped before the line, but I explained to her when I gave the decision that the statute says you have to stop at a point where you can see the oncoming traffic to determine that it's safe to go, and her own testimony was she couldn't see it. So that although she stopped, she didn't comply with the statute because she took off without making sure it was clear and cut the police officer off. So now the issue in her mind was, well, I stopped, that's what you have to do at a stop sign. This is a legal issue. She thought maybe I was wrong on the law, so she challenged that. And now it's, did I make a mistake with the law? That's something the appeals court could decide. For me, in this case, they found I was correct.
But wouldn't that be something that you could easily check in at the Registry of Motor Vehicles about where you have to stop and where the line is? Isn't that
Well, you can get those from the general laws.
the general laws?
Yeah.
So
But-
wouldn't that be something that would be quickly determined so that it would circumvent you having to go through an appeals process? And
Well, the one I
cost
gave
and-
you was pretty clear, I think, and
Okay.
I did read the statute to her when I made the decision. But sometimes the law is not quite so clear, and there might be an issue as to whether or not my interpretation of the law is correct. And on appeal, a judge's interpretation of the law is overturned if the appellate court finds that he's misapplied it, in their opinion. Whereas a finding of fact that you want overturned, you have to find there was an abuse of discretion.
I think a good example of a legal issue would be the reasonable and prudent speed statute,
Right.
because it's so subjective.
Right.
Now, that's a good example of something going up on appeal. You can be charged for, under a statute that says you have to be reasonable, going a reasonable and prudent speed instead of being charged with an actual speeding ticket.
Right, the prima facie speeding law.
You mean it might be snowing, poor visibility, the speed
So
limit
again-
says 35. If you're going 35, you could be in
Is that
trouble.
reasonable, is it
Is that
prudent? So
reasonable?
Yeah.
in that case, you need to take testimony, and again, finding of facts. You have to hear what was the weather, where was the person going perhaps, was there an emergency?
That is a matter of judgment, though, at some point.
Sure.
It's not just that they were speeding or in excess of 35, it was, as you say, prevailing
Right.
circumstances.
And or conditions requiring reduced
Yes.
speed, for example, would have the same issues.
So if that issue comes before you and then someone decides that they're going to appeal it, you said that they need to take a copy of the transcript of the file that's there?
Right.
That's right.
How did they do that?
Well, our court is recorded. There aren't any stenographers in the court, so we have a recording machine. Everything is digital now, so in order to get a copy of in order to reduce it to a transcript, they have to get a copy of the tape, give it to a stenographer who then has to, convert it into a actual transcript, so the hearing.
So would the appellant, the person who wants to appeal, would they be responsible for the cost of that transcription, or is there no cost?
They would pay for
They
it.
would pay for it, but I mean, he or she could try and transcribe it, him or herself
They
as
could.
well.
Right, because the recording itself also goes to the traffic tribunal.
That's right.
Today. In the older days where these tapes were a little bit more difficult to hear, they really required that transcription, and it's still required, is my understanding. But yes, a stenographer listens to it and types it up, and usually they're not long hearings.
And unfortunately, if there's no transcript available, that person will more than likely win the appeal,
If it's unavailable.
Interesting.
if it's
point.
unavailable.
So in the traffic court, I know in the interest of revenue enhancement, there are also court costs at the municipal level for the traffic infraction or whatever. Do you need to pay for the process, the appeals process to go on to? Is there a reason for you to have to pay a filing fee or something to have that trial or court hearing heard
There's
again?
a filing fee to appeal.
$25?
Well, again, it depends on
Yeah.
what kind of
That's
case
right.
is being appealed. For the traffic
Traffic
tribunal,
court.
maybe. Now, you could have a case that was tried in the first instance in district court because they have jurisdiction over that type of case. Some of those cases can be appealed to the Superior Court for a brand-new trial. Some cases that are heard in a hearing board, an administrative agency that get appealed to district court may then be appealed directly to the Supreme Court. So we can go through and talk about all these different types of cases and how it works and where they go.
I think we
And
probably
a
will
good
see how many-
example of that is unemployment appeals.
Exactly,
So
that's an
if
agency
you lose at an
appeal.
administrative agency, you can challenge it and appeal it. They do have an appellate review board.
There's a couple of levels,
Yeah.
you're right.
And then when you've exhausted your administrative
Right.
remedies there, then you can go to district court. If you lose in district court, as David said, then you can appeal it over to the Supreme Court.
Right, so what we're talking about is the Administrative Procedures Act, the APA. So you have an unemployment case, it's heard in the first instance by an application and maybe a hearing officer or something of that nature. If you lose that, then there's another level, a board of review.
That's right.
Or something where they'll look at the record that was made at the first level, and maybe in some instances have some explanation of some of the testimony that was given. Then they make a ruling. If that's still adverse, appeal to district court on the record. District court judge will look at it, make a written decision, and if that's adverse, it can be appealed to the Supreme Court.
Of the lists or options of appeal, I noticed that online, especially when it came to employment or temporary disability disputes, that there are options online to download files or forms, which might make it easier for someone to DIY, do it yourself. But if they are really challenging something and appealing it, do you suggest that they do take a lawyer, because apart from what facts and figures could be on that form, that they might actually need to have some oral argument or something to defend their point? Is that viable?
That's advisable, because there's a lot of, quite often these arguments become legal arguments, and we would research case law, we'd present that as part of our appeal. If we have to argue it before the district court, at least you have an attorney there who will be prepared with case law and the statutory law to make that argument.
Oftentimes, you write a memo to the judge in
That's
those
right.
kinds of cases explaining the law and why it was applied correctly or incorrectly.
In what cases or kinds of cases is there more required than just the transcript? I've read, and you should perhaps help us understand, legal briefs, oral arguments, who does them and in what cases? It may not be for a traffic court,
Right.
but for some other issues. What might
So
they be?
let's talk about a Superior Court case. Superior Court trial is heard over several days. There's a massive transcript for that case. Notice of appeals filed because the case has now reached an endpoint and some party has lost and they've decided to appeal. So a notice of appeals filed, the transcripts are filed. Now what happens, it gets docketed with the Supreme Court. The Supreme Court has certain rules. One of the rules is you have to file a small brief, which it's pursuant to one of the rules. And pursuant to that rule, it's maybe a 3 to 5 page outline of what the issues are. Then
Legal issues they
Legal
need to be.
issues, correct. Then the court may order a hearing in front of one justice to determine whether or not it should go to a full brief, which is one of the things you were asking about, or what's called a show cause calendar, which is a fast track, smaller brief, laying out what the issues are, and the court may, in a smaller panel, there are 5 Supreme Court judges, 3 of them may hear it and determine whether or not there's any merit to the appeal, or just dismiss it, show cause why it shouldn't just be dismissed. If it goes to a full briefing, you're talking about some massive undertaking of writing